Hey there, Aaron here with Law Life and Legacy Planning. I want to talk to you about my newest blog topic today, which is NDAs or non-disclosure agreements. Now, you can read the blog for more of the details to talk about how to define the scope of confidentiality, what types of things are covered, what types of things are not, how to set clear expectations for that employee and what they should expect in the long run, and then also the potential final outcome, the legal recourse, okay? So look at that article, but what I want to focus on in this quick video is how to think about the way you might end up using the NDA down the road. Now, the article talks mostly about how to draft them and how to set them up to be signed by employees. You should do that on their first day when they start a job or even when you make a job offer. But let's say that you have to use it at some point in time because an employee has taken some confidential information and they've used it in a way that's detrimental to you. This could be somebody that's currently employed, or it could be an employee that's left and now they're using it on their own, or they've gone and taken it to a new employer. What are you going to do with it? Well, the reality is it's not a silver bullet. It's not a smoking gun type of thing where you're going to be able to pull out this piece of paper and that person is going to magically stop doing the thing that they're doing because they probably know what they're doing is wrong. So if you remind them that it's wrong, that may not change the way they think about it. But a few things that you can do prior to them leaving is you can just remind employees periodically, right? During training, annual reviews, maybe bring out the documents. If you've got some non-competes or non-disclosure agreements, remind them and document your file. Say, we talked about this on January 15th of 2024. We reviewed these 3 documents. Okay, so you've got some documentation that the employee knew about it. So remind them ahead of time. And then if they do leave and they do take that information and you were to contact me, probably the first thing we're going to do is send them a letter. A cease and desist letter is something that people call it, but basically a letter that says, hey, you signed this non-disclosure agreement. It's come to our attention that you've violated the terms. We want you to stop and stop immediately. And then you're going to set out terms for how they're going to stop and if they're going to have to return the list or something they're going to have to do to prove that they stopped doing what they shouldn't have been doing. If that's not enough, and unfortunately, many times that is not enough, then comes time to actually threaten suit, okay? Now that letter is going to tell them, hey, we're going to bring legal recourse against you if you don't stop. But then at that point in time, there are a few things you can do to kind of escalate steadily, or maybe it doesn't suit your needs to escalate steadily, and maybe we go straight for broke and we sue them, right? There are a few things in the context of that you can do. Sometimes you can seek a temporary injunction, which would be an order from a court in the short term that says, stop using this list, okay? That's a complicated process that takes a lot of time and energy to put together, but that is available to you. At the end of the day, you can have your NDA drafted in such a way that says, here are the penalties if you violate this. If you use this list, here are the damages that us as a company will incur. And so if we have to sue you and we win in court, here's what you're going to have to pay us. It's not a simple formula all the time, but you can do things like that in an NDA because at the end of the day, the NDA is something you can take into court and get a judge to sign off on and say, yeah, you agreed to this non-disclosure agreement, you agreed to the terms, and you violated that. Now we're gonna not punish you, but probably order a judgment of some money damages back to the business. So that's what you can expect on the back end. If you get an NDA in place, it's drafted well, and you have somebody who violates the NDA, that's kind of how it gets used. Now, I don't like having to go there. I never encourage my clients to lean on that, but I want you to be aware of what that looks like on the back end, that litigation process, what that would take to get compliance from an employee that's taking your information. So if you got questions about that, what I've talked about, the litigation process, how you would use that NDA in court, or frankly, better use of your time and resources is making sure that the NDA is prepared well. And as I alluded to, maybe going through your file with the employee every year to make sure that they know what to expect. The biggest thing here is you want to head off that behavior from the beginning, and there are a variety of ways of doing that, both in the way you draft it, the way you present it originally, and the way you review it with them periodically, or if it comes point to termination, okay? So reach out with questions. Again, this is Aaron with Law Life and Legacy Planning. Looking forward to hearing you, and take care in the meantime.